Well, I just don't understand. I mean, I'd like to go for 50-50 legal. And then when I did that, Monica took my time away because I had him every weekend for 8 years.
The parties come in and they can't quite get the parenting time situation squared up. So I say, let's have the friend of the court do it. And that's still not to your liking, Mr. Wheeler?
No, I just mean, I figure it's, what is it, 4 days a month based on what they got right now every other weekend. She gets every week as it is. I'd like some weekends or something. I mean, I know my car is out right now, so I'm kind of dealing with that, but I can get rides and stuff like that to get him taken care of.
Do you think that you have evidence to present?
A frustrated father appears in court, trying to understand why his parenting time was reduced after years of having his son every weekend. He explains that his only goal was 50-50 custody, but claims that once he pushed for equal rights, his ex-wife limited his access even more. What seemed like a simple request quickly turns into a complicated legal situation, leaving him confused and feeling treated unfairly.
At an evidentiary hearing that would sway the recommendation into your favor?
Well, I just don't understand. I mean, I'd like to go for the whole thing for starting this thing was to go for 50-50 legal, which is what my original goal was. And then when I did that, Monica took my time away because I had him every weekend for 8 years.
Yeah, I know. The question is I read your objection, and I just want you to understand something. Is you can keep objecting. I don't have any problem with that. But at some point in time, I think you have to realize that you're not going to get everything you want.
Well, I understand that, but this is my first time objecting. And, a father needs more time with his son.
Right. But now, this from heretofore is going to get very complicated for you, for both of you, because I'm going to have my clerk schedule an evidentiary hearing, and it's like a trial. Okay. And at this trial, you need to bring in evidence. You need to present evidence. You need to have it admitted into evidence. You need to prepare before the evidentiary hearing, witness lists, exhibit lists. You need to exchange exhibits. You need to file a brief outlining the issues. So it's very complicated. Okay.
Just for visitation time? I mean, that doesn't make sense.
Yeah.
Why would a father? Why can't a father have 50-50?
I can't answer that for you because I don't know anything about the recommendation. I don't get that recommendation until closer to the evidentiary hearing. So the parties are free to negotiate something on their own, and then if it's...
The judge listens, but makes it clear that wanting equal custody is enough. The father needs strong evidence. The situation escalates when the judge explains that the case will move to an evidentiary hearing, basically a full trial. Now, the father must prepare witnesses, documents, and legal arguments, turning a personal issue with his ex-wife into a serious courtroom battle.
In the best interest of your child, I would probably sign on to that. But this is what the objection does. The only where to go from here is an evidentiary hearing. So if the parties want to get together before the evidentiary hearing and try and hammer out a solution that might not be everything you want, but you can certainly live with it, I don't have a problem with that. But otherwise, we have to have a trial on your objections, and that's the next step from here. Okay.
It's kind of crazy to me, but I mean, I guess.
Well, the law is very complicated, David.
It is. I know. Yeah.
And if either one of you were thinking of getting an attorney, now would be probably the time to do it. But I'll set that up for you. My clerk will send out the notice, and you'll get notice of when that is. And if we don't hear from you, then I'll plan to conduct the hearing and make a decision after I've heard the evidence, okay?
Okay.
All right, you're all set. Both of you
Cam,
have a great week. Anything in your motion you want to tell me before I hear from...
The ex-wife responds with serious concerns, claiming the father has a history of alcohol abuse and multiple DUIs. She argues that her actions are about protecting the child, not controlling the situation. According to her, safety is a priority, especially when it comes to the child being in the father's care, which adds intense pressure to the case.
Mr. Cam.
No, I would just say that I filed a motion because there is currently no parenting time required. It's something that we've agreed upon through mediation, through the judgment of divorce. Paragraph 11 says that we will be doing this reasonably and mutually agreed upon by the parents, and I don't believe that's been fulfilled. I don't believe it's mutually agreed upon by the two of us at this time.
Well, it's somewhat vague, right? I mean, if the court order that is that parenting time will be as the parties agree, then if the parties don't agree, there is no parenting time, right?
That is correct.
Right. Mr. Cam, what can you shed on this? I read your response.
What can I what?
You want to shed any light on this for me?
Sure. We have originally, when we went through mediation, there was quite a lot of conversations, a lot of agreements that he has not held up to.
The judge explains that while past issues matter, the court focuses on current circumstances. A major problem becomes clear. Both parents are unable to communicate or cooperate. Legally, this alone is enough to reopen the custody case, as poor communication directly impacts the child's well-being and relationship with both parents.
I originally was planning on him having the kids one evening a week, unless they had other activities or things going on where that wasn't possible. I'm not very comfortable with him having the kids in his car just because of his history with alcohol abuse and getting multiple DUIs, and telling me that he doesn't believe he has a drinking issue. So I feel it's a safety matter.
Well, let me ask you this. According to your response, at least it looks like to me anyway, that most of those issues occurred long before you and him signed an October 30th, 2024 stipulation. Is that true?
I believe his last DUI he was still under probation at that time.
Okay.
Or maybe he had just ended probation.
Well, see, my point is this. I can consider changes of circumstance since the last order. And the last order is clearly October 30th of 2024. And anything that occurred before.
Instead of making a final ruling, the judge orders a full investigation into the parenting situation. Both sides will be evaluated, and evidence will be reviewed to determine what is best for child. The parents are given one last chance to settle things themselves, but if they fail, the case will move to trial where a final decision will be made.